So thank you once again for coming to this workshop on, again, natural rights and politics in the early modern period. So despite really the ubiquity of the idea or discourse of human rights in our contemporary political culture and its strong presence in the work of many political scientists, jurists, and contemporary historians, scholarly interest in natural rights, the tradition from which human rights are drawn, remains sporadic and fragmentary, though undeniably rich in certain areas. This may be in part because certain authors have denied any connection between natural rights and our contemporary idea of human rights, or even any connection between the rights of man championed at the end of the 18th century and contemporary conceptions of human rights. Now, despite undeniable evolutions and ruptures over the centuries, this assertion is at the very least debatable. Without giving into a teleological temptation to see in various formulations of natural rights in the course of the Middle Ages and early modern periods, mere precursors to rights language in the age of revolutions of the end of the 18th and beginning of the 19th century, much less in our present, it is important to recognize that this language of rights did not spring from nowhere in 1776, 1789, much less 1948 or the 1970s. So our goal then is twofold. On the one hand, we hope that the papers presented today and tomorrow and the discussions and debates they spark will contribute to a better understanding of natural rights, without which it would be at best hasty to draw conclusions about to what extent subsequent human rights discourse is drawn from them. It is only by taking care to examine how natural rights were used in different contexts that we can properly grasp the nature of potential ruptures and continuities. At the same time, we hope this workshop will contribute to our understanding of the role that natural rights could play in legitimizing or delegitimizing different political ideas, institutions, or actors, and in responding to political crises in the course of the early modern period itself. Natural rights were long considered the expression of a possessive and individualistic liberalism, as C.B. Macpherson would have it, born in tandem with capitalism and serving as its justification, or else, to follow Michel Villet, as a nominalist aberration of scholastic thought in particular. However, the pioneering work of medievalist historian Brian Tierney shows that subjective natural rights, seen as inhering in every individual in function of his humanity, date back at least as early as the 12th century, and some scholars have argued even older origins in Roman law, where the term jus naturale originates, or in Stoic philosophy. In the authors Tierney studied, far from being an expression of the omnipotence of the acquisitive will, natural rights were conceived as limited by the principle of reciprocity. Social rights, such as the right to subsistence, have thus been proven not to be a late addition to the natural rights tradition, but some of the first rights theorized by the medieval jurists of the University of Bologna. Although this tradition presents a certain diversity and evolved in the hands of different authors, notably in response to the major crises of the arrival of Europeans in the Americas, or the Protestant Reformation or Reformations, with which the early modern period opened, 17th and 18th century authors like Thomas Hobbes or the physiocrats of the 18th century represented real epistemological breaks with the basic tenet of reciprocity by introducing the idea of an unlimited right, whether that be the right of the individual in the state of nature or that of landowners, the classe des propriétaires, as famously depicted by François Quesnay. Some scholars have had a tendency to attribute to one or the other of these ruptures the creation of, quote, modern natural or human rights. Hobbes has thus been credited with this invention, even though, to my mind, such a claim seems incoherent with his reduction of natural rights to the sole imperatives of self-preservation, just as it is with the absolute sovereignty he accords to the Leviathan. Other scholars have affirmed the decisive influence of the physiocrats on the language of the French Declaration of the Rights of Man and Citizen of 1789. However, alongside the conceptions, which are often termed liberal, of natural rights as the intangible right of property owners, the older conception, that of reciprocal and therefore limited rights, continued to coexist and was also subject to evolutions that made it arguably just as modern. This coexistence can be observed even within the drafting of official declarations of rights, leading to certain ambiguities in these texts, notably concerning property. Florence Gautier, a historian specializing in the French Revolution, and working backwards from there, has uncovered the connections between the natural rights proclaimed by the medieval jurists, Bartolomé de las Casas and the scholastic theologians of the school of Salamanca in the 16th century, or those asserted by the levelers of the First English Revolution and John Locke during the 17th, and the Age of Revolutions between the end of the 18th and beginning of the 19th centuries. Each of these key sequences has sparked a considerable degree of interest, whether on the part of historians, jurists, or philosophers. Following Florence Gautier's Triomphe et mort du droit naturel en Révolution, there has been a renewed interest in the role of natural rights in the French Revolution and in the other revolutions of the same period, notably through the Séminaire L'Esprit des Lumières et de la Révolution. Stimulating and rich debates have taken place and continue to flourish on natural rights in the thought of key figures like Francisco de Vitoria, Hugo Grotius, or John Locke, and a number of scholars have studied the elaboration of the English, American, and French declarations of rights. More isolated, but no less interesting work on natural rights in the writings of Enlightenment philosophers like Gabriel Bonneau de Mably or Denis Diderot have been published, while political scientist Michael Zuckert has highlighted the importance of natural rights in the American Revolution. One important subject of controversy has been the alleged incompatibility of the natural rights tradition with what is often called classical republicanism. G.A. Pocock, one of the pioneers of the Republican renewal in historiography, has theorized a classical republicanism characterized by positive liberty and in opposition to a liberalism which he identifies with natural rights and a negative conception of liberty. The freedom to participate in public life might indeed seem to be contrary to freedom conceived as a sphere of action protected from political authority. But another member of the Cambridge School, Quentin Skinner, has nonetheless made apparent that two forms of negative liberty could coexist in the early modern period. Liberty as non-interference, but also liberty as non-domination, to use philosopher Philip Pettit's terminology. If the law constitutes a constraint on liberty according to the former conception, for the latter, the law is instead the only guarantee of liberty against arbitrary power. As the reflection of Christopher Hamel, who could unfortunately not be here with us today, but in any case, as his reflection and that of others have shown, the last notion, this notion of liberty as non-domination, was not in the least incompatible with natural rights, either in theory or in practice, in the writings of numerous actors who drew simultaneously from the Republican and natural rights heritage without contradiction. Likewise, the emblematic case of the philosopher of the Neapolitan Enlightenment, Gaetano Filangieri, a coherent theorist of natural rights and constitutional republicanism, allowed Vincenzo Ferrone to draw the same conclusions.
All right. So, nonetheless, the undeniably abundant scholarship on natural rights in the early modern period still presents certain gaps, so that some old and ongoing historiographical debates deserve to be revisited or deepened. It is for this reason that we propose a workshop on the deliberately broad subject of natural rights and politics in the early modern period, here at the Global History and Governance program of the Scuola Superiore Meridionale. This insistence on the relationship between natural rights and politics is intended not only to encourage the interrogation of natural rights as a set of theoretical, philosophical, and political concepts, but also, and above all, to spark interest in the multiple uses of ideas drawn from the philosophy of natural rights in precise political, economic, and social contexts. How did natural rights serve different political projects? How did transforming contexts lead to the evolution in the conceptions of natural rights on the part of historical actors and thinkers? So to provide some answers to these and other intriguing questions, we propose three axes of research. So the first, natural rights and republicanism. If we accept, based on the studies already cited, that natural rights can be compatible with republicanism, or at least with some republicanisms, then a vast field of inquiry has just been opened up on the articulations between the two, which may vary according to the period, the actors involved, and the historical background. In other words, we urged potential contributors to pursue the investigation launched by the 2008 workshop Republicanisme et droit naturel, by inverting its terms. If a philosophy of natural rights can be republican, does that imply that it has necessarily to be so? And which republicanisms in the plural are at issue here? We hope that particular attention will be paid to the choice of vocabulary and to the definitions and resemantization of interrelated notions such as liberty, equality, virtue, happiness, as well as to intertextuality. But also the political, social, economic, cultural, and religious contexts that could orient and shape the employment of this key concept cannot be overlooked. The papers presented by Laurent André and Andrea Moretti will address and shed further light on these problems by considering respectively the republicanism of the ideologue and the Cisalpine Republic in Italy. We also hope that despite their absence today, Paula Story and Lars Cyril Norgard's paper on the case of Denmark-Norway between 1648 and 1670 will further enrich our understanding in the projected publication of the proceedings of the current workshop. The origins, so second, a second axis of research, the origins and the evolution of particular natural rights. The enumeration of natural rights and of the social and political rights that may derive from them has never been obvious. Thus, we decided to also propose a focus on which rights emerged in the course of the early modern period, on how they were theorized and included or excluded in declarations of rights, and on how they were interpreted across the centuries, and in particular in revolutionary transitions. Some rights and chronologies have received more scholarly attention than others. Needless to say, rights like those founding popular sovereignty, freedom of expression, or the often ambiguous right to property have given rise to a certain amount of studies, especially as far as revolutions are concerned, even if the interpretations they suggest are far from definitive. Other rights, even among the most fundamental, have yet to be investigated properly. For example, historians of religious toleration have insisted on its pragmatic aspects in the early modern age. But this raises the question of how and why freedom of religion, in one form or another, was declared a natural right from the beginning of the American and French revolutions. By dealing with objective and subjective natural rights and with little heeded rights, such as that to burial, the papers by Diego Carnevale, Davide Dainese, Susan Longfield Carr, Alberto Scigliano, and Catherine Chaverty will demonstrate the variety of natural rights and the complexity of the ramifications and theoretical and practical implications. So a third and last axis of research is that of the concrete applications of natural rights, in the implementations of natural rights. So we resolved to concentrate on natural rights at the heart of the events, the historical events. How and why did historical actors during revolts, revolution, or attempts at reform appeal to natural rights in order to justify their policies on the one hand, and how on the other did they interpret the different natural rights at stake while conceiving these policies and seeking to put them into practice? How did observers view revolts and revolution through the interpretative grids of natural rights? The uses and manipulation of natural rights by revolutionary protagonists primarily, again, in the American and French revolutions, are well documented and have inspired the greatest quantity of research. Some questions brought up have been, for what reasons and how did, say, Thomas Jefferson, Robespierre, Thomas Paine refer to natural rights? To what extent was the abolition of slavery indebted to the natural rights tradition? What are the implications of the more or less general exclusion of women from the universality of natural rights? These are, and similar issues, have not been fully explored yet, but other actors and other periods deserve further investigation as well. The uses of natural rights during the Protestant Reformation and the wars of religion, a key moment both for the questions of religious tolerance and resistance to oppression, have inspired a few studies, but the field remains relatively open to new inquiries. No less important is the problem of the role played by concepts of natural rights and revolts of the early modern period, including peasants' revolts. Gautier and other historians found the presence of the natural right to subsistence in the Flower War of 1775. Meanwhile, in his book La Rébellion Française, historian Jean Nicolas has identified over 20,500 cases of revolt just in France during the century prior to the Revolution. It seems implausible then that the Flower War was an isolated case. The papers by Thomas Croiset on the Jesuits in Paraguay between 1609 and 1641, and by Valentina Topieri on the claim for women's rights in the 18th century, will offer new insights into the attempts to turn natural rights into reforms and governmental practices for specific religious and political goals. In order to include as many interpretations and implementations of natural rights as possible, we avoided fixing rigid chronological, geographical, and disciplinary boundaries. The choice to limit this workshop to the early modern period is admittedly an arbitrary one, made for practical reasons. Within these inevitably blurred lines, however, we will follow a chronological order in the papers presented so as to account for some of the intellectual and political transformations that the natural rights underwent between the 16th century and the 18th. Although implicit in at least some of our elements of inquiry is the question of the origins, our goal is to avoid all kinds of teleological determinism. Our hope is that by proceeding chronologically, we will be able to appreciate more the arguments, the definitions, and the practices in the context of each given political moment. So before we start, we'd like to thank the rest of the scientific committee, all the participants who have come here to Naples, and of course, Gia Caiotti for the support. And now, without further ado, I give the floor to Marc Bellissa for the first panel on humanism and reformations. So thank you very much.
Not a problem. What is a problem is that Susan and Giulio approximately told everything I wanted to say, so my introduction is going to be very short. Our first panel will be centered on the period of what we call humanism and Reformation, or what we call, as French, the première modernité, from 1500 until 1648, approximately. Of course, as Suzanne and Giulio have said, the ideas and practices of natural rights did not appear suddenly at the beginning of the modern period. In 1500, they already had a rich and complex history, from what is called jus naturale in the Roman Republic and Empire to the late Middle Ages. In his time, Leo Strauss had drawn a line, a frontier between the natural rights of the ancients in the Middle Ages and the natural rights of the modern. But as the works of later academics have shown, have amply shown, this line, this frontier, was completely artificial. Not to mention its political and conservative sous-entendu, in the case of Leo Strauss. Later, the Cambridge School, with Parker, Skin, and Dunn, has shown the continuity between modern natural rights theories and medieval theories in Renaissance Italy and in the English-speaking world. Closer to us, Brian Tierney, as Suzanne has reminded us, has masterfully demonstrated that the roots of modern natural rights are to be searched in the 12th and the 13th century. I will not come back here on this conclusion. I just encourage those who have not yet read The Idea of Natural Rights, Studies on Natural Rights, Natural Law and Church Law, Atlanta, 1997, Italian translation in 2002, and Liberty and Law, The Idea of Permissive Natural Law, Washington, D.C., 2014, to do it ASAP, as the Americans say, as soon as possible. Translation for everybody. This afternoon, we are welcoming four colleagues. David Danese is Associated Professor, where is he? Sorry, he's here over there. David Danese is Associate Professor of History of Christianity at the University of Bologna. He will talk on the subject, objective and subjective dimensions of law, the transformation of jus naturale in the practicals of the 16th century. And he will show that the 16th century jurists can be considered as forerunners of Grotius in a theological perspective. But he will explain to us what the practicals are. It will be very interesting. Susan Longfield-Carr is an associate professor in the Department of History in the University of Cincinnati. The paper is entitled Between Natural Law and Human Right, Jus Gentium in Humanist Jurisprudence, and she will explore, I quote her, how legal humanist jurists understood and used jus gentium to address local and trans-regional problems within Renaissance Europe. Alberto Ciliano is Professor of History of Hebraism at the Università degli Studi di Torino. He will talk about the Jewish sources and more precisely of the Talmudic tradition of law in early 17th century natural law theorists like Selden and Grotius. Our last speaker for this afternoon will be Thomas Croiset, who is doing a doctorate at the European University Institute. He will talk about the use of natural rights by the Jesuits in their sometimes armed resistance against slave hunters and against their own superiors inside the Jesuit orders or inside the church. Before letting the microphone to our colleagues, I would just say that what strikes me in these four papers, in the resume of these four papers, is that they carefully avoid all theological approach to the history of natural and human rights. The first modernity talks for herself and is just not a sort of anticipation for later developments. This historical and practical approach, instead of the old history of ideas approach, is just what the organizers wanted. Thanks to all of you.
There's broad consensus that the image of Jean Bodin as a theorist of absolutism should be somehow reconsidered. Jean Bodin exaggerated the novelty of his analysis of political power, and historians have exaggerated the novelty of his exaggeration, as Ken Pennington, a well-known pupil of Brian Turner, demonstrated some 30 years ago. In Pennington's reconstruction, Bodin's state was seen to be the natural development of the medieval Respublica, in spite of how scholars had previously approached it. By contrast, Auctoritas Potestas was legibus soluta insofar as, paradoxically, it was deeply rooted to lex. One passage from the Republic expressed this conviction perfectly, and I've quoted it in my handout, the passage I'm referring to. I won't repeat Pennington's arguments here. Instead, I will point out that Bodin's political paradigm wasn't the only model with which the idea of absolutism was usually expressed in the 16th century. In fact, in a trend that Pennington himself had recognized in Machiavelli, and which in the 16th century was represented by the so-called practicals, judges, not actually university professors, author of books that were used in tribunals, for example. A clear absolutist view of society is attested. And this is very different from the one Bodin inherits from the Middle Ages. Of course, we are dealing with a very peculiar society. I shall focus here specifically on a figure that is reasonably well known to medieval and modern Italian legal historians, Pierino Belli, a judge from Alba in Piedmont, who served first under Charles V and Philip II of Spain, and after Cateau Cambrésis at the court of Emanuele Filibert of Savoy as state councillor. Only one work is attributed to Belli, the treatise De Re Militari et de Bello, first printed in 1563 in Venice. We also have a manuscript copy of it in the Turin National University Library. Despite little consideration from historians of political thought in the early modern age, the success of and distribution of Belli's work were quite significant in earlier times. And the treatise's inclusion in the 16th tome of the Tractatus Universi Juris, of course the Venice edition on 1583-84, earned Belli a double mention in Grotius de Jure Belli ac Pacis, and earlier served basically as, I would say, the stone guest for Alberico Gentilis de Jure Belli. However, beginning with the rediscovery of Belli in the 19th century by Pasquale Stanislao Mancini and up to Peter Hagemark in 1983, all of this came at a cost. Belli has since been regarded exclusively as a precursor to Grotius and Gentili. What was lost was an understanding of both the peculiarity of Belli's thought and its historical significance. As a consequence, an investigation based only on a philological attention has been preferred, with the only exception of Diego Quaglioni, whose analysis I am following here. As a military judge, Belli's primary aim wasn't to reflect on the Respublica. His chief intent is encoded in Part 7 and specifically Part 8 of his treatise. It was to provide a catalogue of crimina militaria that would assist and enforce the disciplinary action incumbent on those with an actual monopoly of power. A quite wide range, I would say, from the princeps up to the dukes and capitanus or colonelius. That being said, in order to do that, he needed of course, to base his project on certain assumptions that, to me, reflect a deep awareness of the current condition of events, the same awareness of the very socio-political framework that was very clear already to Bartolos de Saxoferato in his preface of his Tractatus Represaliarum. Belli's split from the medieval world is articulated in 3 steps. First, Belli sets arbitrariness, it's really crucial, at the very heart of the legal system of the medieval Christendom. Indeed, auctoritas and potesta are properly and explicitly defined as libido, whim. The term is central to Belli. In his work, it occurs from the very first pages and recurs consistently throughout the whole treatise. A few decades later, starting from a passage in Alciato Sparerga that Belli had commented upon previously, Alberico Gentili would come to distinguish wars caused by libido and just wars, thus clearly departing from those who, like Belli, had never denied libido a certain degree of justness. Among the variety of passages in which Belli deals with libido, one is especially famous, and this is the only one I'm gonna read in Latin to save time, which is intriguing because Belli dismisses with simplicius an entire legal tradition of which he has shown himself a profound connoisseur. Ego vero simplicius puto populum quem libet ac gentem, quae suis vivat legibus, atque arbitrio, aut estiam regem, aut alium principe suo mino iuris, posse cum libeat et causa subsit, bellum indicere. Therefore, anyone who lives by their own laws is permitted to wage war if they need to and have libido for it. Law doesn't matter. He who has the actual monopoly of power is bestowed with it. He is allowed, for example, to engage in rape, a crime that, as it were, Belli, following Baldo's lead, defines of such gravity as to be placed among the atrociora that Roman law punished with capital punishment based on intention only. Second step, the soldier himself too, moreover, is featured in a condition of inuria by a non-juridical status, not only the auctoritas or potestas to which the soldier is subjected. Part 7 of Belli's treatise is entirely devoted to the privileges of soldiers, to the exemptions that military law granted them in the digesta and the tradition of their commentaries. In other words, even the miles, the soldier, is to some extent legibus solutus. Indeed, the types of waivers to the jura, naturale, gentium, so on and so forth, that Belli acknowledges for soldiers in respect to tradition are quite interesting. And among these, once again, is rape, which is one of the prerogatives of the princeps. And I quoted the passage I'm referring to in the handout. Moreover, Belli goes so far as to grant that the action of soldiers can be corrected even in cases where it's governed blindly by temeritas and fortuna, as you can see in the passage I've quoted. And those in temeritas and fortuna, Belli makes a sharp departure from tradition. To make a specific case, the Cardinal of Ostensis Henry of Segusio, in his Summa Aurea, commenting on a decree of the Liber Extra, had set a list of justa bella against various bella injusta, among which there is the temerarium one. A war led by temeritas and fortuna is led not by reason and law, but by arbitrariness and chance. It's significant that a jurist with Belli's background or training should endorse this. The third departure from the Middle Ages is the type of lex that goes with auctoritas or potestas. Belli acknowledges a variety of jura, Roman, feudal, canon, naturale, divinum, gentium, with different orders and hierarchical positions. Indeed, he constantly exhibits a precise knowledge of them, but then, just as precisely, dismisses them. In other words, in Belli, no law serves as Schmidt's Hegum or St. Paul Catechon, that is, a restraining power. There is no system of laws that can be disposed of to diffuse the arbitrariness of those who hold the actual monopoly of power. And after all, how could we expect such a thing if arbitrariness, as I said, is its main feature? In the clear, resigned disillusionment that surfaces throughout Belli's treatise, there's only one law, if it can still be called such, the market law. Firstly, in dealing with the crime of defectors, those who flee from the battle and seek refuge with their enemies, Belli compares them to Bartolo's rebels. That is, he follows and adopts the argument where Bartolus afforded rebels, who were guilty of a capital crime in their own state, with rights granted on a level hierarchically above the one of jus civile, level of jus gentium, naturale, or divinum. Consequently, it is quite confusing. Bartolus will be clearer in defining jus gentium. Consequently, for Belli, it's fitting that the defector should be punished with the utmost cruelty by his own sovereign, as Bartolus' rebel was. But it doesn't deny him the right to cross over the enemy. However, for Belli, this right isn't granted among those jura that, according to Bartolus, belong to reges vel populi who non recognoscono imperatorem in dominum, but within the mere principle of convenience, a milder contractual system of rights and duties governed ultimately by the market law. Belli spitefully admits with an eloquent amen, once again very close to the Simplicius we read before, that legimus in annalibus, that multis perfugis, et qui ab unis ad alius transierunt, et honorem habitum ne premia data, and so on and so forth. Then he closes with a warning to the princes, caveat ne perfugas contemnant neque orum commoda et dignitatem negligent. Can be said that in Belli's view, the just, de facto reward turns out to be only the jure condition that remains standing in a wartime scenario filled with all manners of violence, such as those in which he operates as a military judge, as a practical, let's say. From a historical legal point of view, this finalizes a process that began with Innocent IV, who had interpreted the feudal pact by resorting to the Roman privatist institution of the Actio Mandati to explain the feudal prince bond. Belli invokes this in the theoretical premises of his treatise and expands of its far-reaching consequences in part 7, devoted to administrative military law. Comparison between the printed edition and the manuscript version of the work allows us to recognize a section that seems to have been designed as an independent treatise, let's say. This is paragraph 23 of Title 6 of part 7 of Belli's work. In the printed version, it corresponds to a large segment of about 4 pages, that doesn't appear in the manuscript version concerning the identification between the Roman institution of militia, which corresponds to soldiers' compensation in belli, and the pensiones, which Belli states hodie exercent reges liberalitatem in suos benemeritos. In doing so, he seeks to normalize a situation that is in fact very different from the Roman world of Roman antiquity, and its medieval reinterpretation. The pensiones he speaks of, an expression of the liberalitas of the prince, are actually an extrinsic expression of the arbitrariness of the prince and anyone who can actually employ military force, from magister officiorum to duces, of course, to reges and principes. I insist that it's an arbitrary act that presupposes no use or no lex outside the very whim of those who have the full disposal of military force, for those capable of deploying, maintaining, discharging, ultimately paying for it. In this sense, it's interesting to examine the list of examples of premia, as necessary we read as punishments, Belli says, with which Belli interrupts his constant reference to legal sources in order to turn exclusively to the Roman historians, to whom he dedicates the entire title 4 of the 7th part of his work. Here precisely is a cynical acknowledgement of the current condition of things, which Belli presents through a quotation very famous from Ovid's Ars Amatoria, aurea nunc vere sum saecula, plurimus aulo venit honor. Belli seems resigned to note that it's to the market and its rules that one must look to in resolving long-standing disputes in feudal law over the necessity to render wartime assistance to one's lord. In spite of the principles and practices of feudal law, the stipendium, Belli states, is the sole distinction between civilian and the soldier. Therefore, reference shouldn't be made to a system of immutable, rational leges or iura that can be disposed of, but rather denique ex arbitrio et liberalitate donantis, he says, about which there's neither certainty nor possibility to make any prediction. How should we interpret this data? What sense is to be made of these two extra-legal entities as aborigine the princeps, or more general, or the more general actual holder of the monopoly of power, and the miles are, until at some point one might say they are placed in mutual relation by a connection far weaker than a private contract and ultimately an agreement regulated by the market law. Given the emphasis on libido, Belli could have referred, for example, to Alberico da Rosate, probably the only jurist of the classical jus commune era who legitimized some arbitrariness in prince's action. Instead, his reference is another. In the theoretical section of his treatise, precisely part 1, title 3, Belli recalls the conception of war made famous by Paolo Castrensis, a highly successful view. Through Alberico Gentili, it would reach as far as Hobbes and Locke. Paulus Castrensis was notable for even clearer than Bartolus, theorization of the possibility for individuals to act as judges of themselves. According to Paulus, before justice was established in a condition of inuria, analogous to that of Belli's prince and soldier before their market agreement, by jus gentium, it was possible to wage war either by virtue of one's propria auctoritas or by manus principis. And Belli explicitly refers to the thought in the passage I've quoted next. The presence of this reference among the theoretical premises of the Re Militari et Bellum Tractatus indicates that Belli's Societas Militaris bears strong similarities to the idea of the state referred to by Paulus Castrensis. Nevertheless, Belli's position looks profoundly different from that of Paulus. Propria auctoritas in Belli is an impoverished version of jus represaliarum, which is not rooted in a legal level higher than that of jus civile, that is, jus Romani, and finds its meaning only in the presence of the liberalitas of those who can assure him better pay. It is pure abandonment to the haphazard nature of the meritas. Its action has no certainty or predictability, as I said. As for the main feature of Regia Manus, in Belli, as we have seen so far, it can be defined as a potentially unrestrained whim. It must be said that in the history of medieval, can see feudal law, the absolute nature of prince's power has only one consistent precedent: the crusade against heresy. Throughout Middle Ages, heretics were ever perceived in the absolute, as the absolute outlaws. They were deprived of any legal status, as this was simply denied to them. The authority of the Pope as Prince of Christendom over heretics remained without limits throughout centuries. In fact, heretics are simply outside the sphere of law, and holy wars against heresy from the Third Lateran Council to Henry of Segusio, Cardinal Augustiensis, is the only sphere in which the Pope's authority isn't constrained or restrained by anything. To use the language of Cardinal Augustiensis, of Henry of Segusio, only in the face of heresy is the Pope's potestas unrestrained by what licet or decet, and it is truly absolute. Now then, a survey of the sources employed by Belli, which I can't conduct here and whose results I will only summarize, shows that Belli stands at the end of a process of secularizing that very violence that medieval holy war theories had reserved for the heretic. Indeed, here he assigns it to the punishment of the undisciplined soldier. For Belli, the Disciplina Militaris, as it is codified in part 8 of his treatise, regulates a sort of, let's say, holy war on indiscipline. And since it is the outcome of an act of arbitrary and non-juridical veto, such a discipline process produces a juridical order, by the order of an army, not of a state, whose Grundnorm, to paraphrase Hans Kelsen, is, however, entirely political. It is Giuseppe Galasso who referred to Hans Kelsen, and it is beautiful for me to remember him here in Naples. I wish to emphasize that Belli Societas Militaris has all the features of a Respublica. Belli formulates his proposal in explicit antithesis, and again I must summarize the research results I've conducted elsewhere, to Augustine's model of state body of Christ that permeates the entire Decretum Gratianum. Indeed, Belli dismisses as concili et non precepti a form of Augustinianism permeating all medieval legal and theological thought on warfare, at least from the Decretum to Aquinas. Belli challenges Augustine's effectiveness, so to speak, ex opere operato, of political authority that places the judgment and action of God's wrath in the eschaton. For Belli, there's no auctorita superiore, justa causa, recta intention, to predetermine outcomes and judgments on war. According to him, once due formalities are fulfilled, whoever tutari armis licebit causam suam, with no preconception. Augustine's sacramental dimension of state is thus replaced by a new corporeality, a new body, of just two limbs, according to Paulus Castrensis' matrix. An objective jurisdiction to be executed without appeal, and the blind, not yet juridical, but subjective instinct of survival that becomes law only to the extent that for convenience it submits to such a jurisdiction. So, having reached the end of this presentation, I think the alternative represented by Belli's model compared to Broaden's is quite evident. Although Belli refers to an army and Broaden to the state, even without addressing aspects of the work's circulation, which would further confirm actually the hypothesis, the success of Belli's model in the short term seems to me clear. If the execution of discipline means enacting a kind of crusade against indiscipline, a conflict on the scale of the 30 Years' War, which broke out after 63 years of peace in the Holy Roman Empire in an attempt to suppress the indiscipline of imperial vassals like Frederick V of the Palatinate, seems its most natural consequence. From this point of view, it should be enough to recall that between 1563, the printing year of Belli's work, and 1618, the only contexts in which Part 8 of the treatise, the one of military criminal law, would be appreciated were German universities and tribunals. That being said, determining whether Belli's military society is the prototype of the modern state or a potential but abortive, let's say, model akin to Paolo Prodi's Renaissance church state, later replaced by the Broaden tradition, is beyond the modest scope of this paper. With regard, however, to our workshop, I believe that the figure of Belli can help us understand a specific datum. If, as Brian Turner has repeatedly shown, in the long-term roots of modern jus naturalism are medieval, there remain to be clarified at least a few details of how from a feudus, a feudal covenant, we arrive at Rousseau's social contract. It is undoubtedly true that in Belli the tradition of natural, rational, divine rights and so on is entirely dismissed. On this, Belli isn't perhaps a precursor of modernity, and studying him at most clarifies certain aspects of Europe in the long Iron Century. But only this positive, if I may borrow a term and a concept by Foucault, that causes a certain individual and non-juridical prerogatives to be protected in a legal system, I believe that the long history of jus commune, to which also Belli belongs, still has much to teach us.
So when I saw the advertisement for this conference, I thought, wow, I finally get to talk about the things that I've always wanted to talk about, but I couldn't because I had to write a book first. And that book was called Jus Gentium in Humanist Jurisprudence on Justice and Right. And it goes through the different ways in which Boudet, Zazius, and Alciati go through and unpack Title I, Chapter 1 of the Roman Digest and reinterpret it fundamentally when they do it. One of the reasons why I'm excited about this is now that I've shown all of that work there, I can actually talk about what I've always thought of while reading Tierney, Tuck, Skinner, Pocock, the whole lot, including Marty Koskiniemi, who works a lot on Jus Gentium, is that there's a little bit of fuzziness when we talk about the impact in place of humanist jurisprudence. It's usually folded into a kind of narrative where it doesn't fit or it's artfully ignored so that you don't have to worry about it. So I just want to preface that by saying, that's where I'm going to put my focus. So I have some questions that I frame my bullet points of. Hopefully I'll get through all of them. So my first is, what if the attempt to find the missing link between natural and human rights has inadvertently led to an emphasis on the category of natural law, when the real work might have been done elsewhere, namely in relation to jus gentium? Especially by those who redefined the Roman legal category as a quality of natural law, but not natural law, the source of universal rights, subjective use, and a fundamental criterion of justice, objective use, in the early decades of the 16th century. What if instead of looking at the history of jus gentium through the lens of European expansion and international law, we have inverted our inquiry and explored how legal humanist jurists understood and used jus gentium to address local and trans-regional problems of authority within Renaissance Europe? What if taking the category of jus gentium more seriously on the local level was in the end to challenge and expand our understanding not only of natural law and rights, universal rights in the early 16th century, but also our assumption about the centrality of such categories as the jus commune in the early modern period more generally? What if, instead of interpreting the history of liberty and freedom as a reaction to state formation, we attempted to explore how 16th century jurists reinterpreted the legal tradition which they inherited from the Roman and Byzantine past? And in doing so, we paid attention to how they fundamentally altered basic court categories and understandings of the rule of law, not to modify or demolish older customs, rights, and liberties, or to augment the power of princes, kings, emperors, and pope, but rather to preserve traditions, to preserve rights, and to preserve freedoms by appealing to the jus gentium. In other words, what if we take the early modern discourse of law and order and the limits of each on its own terms instead of a so long preamble to the legitimacy of liberal democracy, or a prehistory of the triumph of liberalism, and with it, modern understandings of human rights. Drawing on the works of 16th century legal humanists Aldrich Zazius and Andrea Alciati, I hope to show that if we want to rethink the history of natural law and natural rights, and that link, which I think that we should and we need to, we might be better served by asking some of these questions without attempting to establish a direct link, a teleology, a linear story, or a narrative that can take us from natural law to human rights. And maybe instead of just natural rights to human rights, we might want to think more carefully about the category of jus gentium before it was turned and twisted and used for different purposes in the 19th century to kind of understand what was going on. So why legal humanism? Well, for humanist jurists such as Zazius and Alciati, natural law, jus, and jus gentium were central categories which they used to explore, discuss, and make arguments for and against changes in political, economic, and legal authority during the early 16th century. They did so by investigating the corpus of Roman law with reference to a variety of sources, especially sources from history and moral philosophy. This enabled them to reach far beyond the lattice work of normative interpretations and explanations of fundamental categories of law put forth by late medieval scholastic jurists, canonists, and civilian and theologians. Although both Zazius and Alciati had set out to restore Roman law as the Romans knew it, in effect, they reinterpreted it in different ways and to differing degrees. This was especially the case in relation to their understanding of jus gentium, which they interpreted as universal customs in common within and between communities that neither were limited by time or space, and also were kind of signals to a universal idea of dignity. They also reinterpreted use, which they understood as both the art of good and equity conjoined, objective use, and as an intrinsic and inherent characteristic of man qua man, subjective use, shared by all without distinction of time or place or space. That Zazius and Alciati offered new interpretations of these basic categories is of course not surprising, especially given that they were writing in an age characterized by the creation of new forms and the expansion of older forms of legal authority, which introduced a historical problem into the study of law. Namely, how do you protect customary rights and obligations in the face of new laws and vice versa? In this respect, it should be no surprise that the local context in which they were writing, Zazius in Germany and Alciati in Italy and France, helps to account for how they defined and used the categories of natural law, jus, and jus gentium in order to accept or reject changes in civil laws, and by extension, customary laws in the early 16th century. For example, as a lawyer and city councilor in Germany, Zazius he participated in the extension of legal, political, and economic power of the city of Freiburg over its countryside, but rejected the inverse, the tightening of the emperor's grasp over legal, political, and economic structures within the imperial city of Freiburg. In both cases, Zazius used the fundamental categories of jus and jus gentium, which he argues jus gentium is the fourth quality of natural law, the one that's the furthest away from natural law, but also happens to be the source of most natural rights, to make arguments for both the limits and legitimacy of new civil laws and civil authorities. In Alciati's case, under the patronage of conflicting rulers in and beyond Italy, he used the categories of natural law, jus, and jus gentium to argue for the necessity to recognize limits and boundaries that existed, or at least should have existed, between different rulers, superior and inferior princes, in relation to one another, as well as between rulers and their own subjects. The legal humanists were exemplary of a broader shift that occurred throughout the early modern period. That is, while it was the case that Zasius and Alciati were, and continue to be, the most famous legal humanists of the early 16th century, their application of the Studiae Humanitatis and interpreting Roman law was not their unique innovation. We all know that these new methods were beginning to be applied to explore and reinterpret inherited bodies of knowledge, including theology, canon law, medicine, and philosophy, both within the university faculties and outside of them throughout Europe. Yet Zasius and Alciati were exceptional in relation to their scholastic counterparts, precisely because through the application of their methods, they offered a fundamentally different and alternative interpretation of key categories within both Roman law and scholastic jurisprudence. And it was in doing so, in rethinking and reevaluating fundamental categories within Roman law, that Zasius and Alciati, among other legal humanists, brought jus gentium into the core of early modern political and legal thought, away from the margins and in the very center. Despite the highly technical use of legal theory and humanist rhetoric, Zasius and Alciati's interpretations rested on relatively straightforward definitions of basic Roman legal categories, which they used to explain how the different kinds of law were related to one another, philologically, legally, and historically, and the most basic category that every kind of law in the corpus of Roman law shared, of course, was jus civile, jus naturale, jus gentium. Both Zasius and Alciati understood jus as one, the art of good and equity conjoined, objective right, the right order of things, what is just. Two, the source of one's right to meet force with force in order to protect themselves and their families, subjective right. And three, the obligation of rulers to protect their subjects by waging war and contracting peace, so sovereign rights as well. Accounting for the relation between jus gentium, jus naturale, and jus civile, Zasius and Alciati explained how each was related to the other by focusing on why they are all what they all shared in common, again, jus. And understanding jus was also the key to understanding how one type of law, for example, jus gentium, could be used to reform another type of law, like jus civile, when it departed from justice. This is a fundamental break from traditional understandings of Roman law by the Romans and also by scholastic jurists, that you could use jus gentium to reform civil law instead of it just being something on the margins. In their treatments of the foundational categories of jus and jus gentium, Zasius and Alciati also attempted to correct misunderstandings and misinterpretations by traditional jurisprudence. Focusing above all else on theology, moral philosophy, and history, they presented an interpretation of Roman law wherein they emphasized the origins of law, the origins of society, and the origins of international society as well. In accounting for these origins with reference to real and imagined history, Zasius and Alciati explained why and how universal rights and obligations shared by all mankind, regardless of time and place, extended from the categories of jus gentium, rather than directly from natural law. So for Zasius, jus gentium was a central and fundamental category of law for several reasons. Following Gaius's definition, Zasius held that jus gentium was a form of natural law known only to man, not to animals, and as such, it signified man's venerated position vis-a-vis the animals, that is, his dignity. Jus gentium as an expression of natural law and a record of justice or objective use for Zasius was also higher order than the civil law because it was the source of man's natural rights and obligations. And I use the word natural here because they exist for man regardless of what political system he lives in or what kind of society he lives in. And this includes the right to protect oneself, the right to protect one's family, the right to protect property, the right not to be enslaved, the right to not be forced to live under tyranny, and things like this. Man has natural rights and natural obligations because he has an innate sense of justice for Zosius. Man needs rights and obligations because reason and passion, his twofold nature, can be in conflict. As a result, so too can the civil laws, which are created by man, be in conflict. Those who make the laws and those who administer them can do so in accordance with their interests without concern or respect for the interests of others, without concern for equity and good conjoined. In these cases, subjective use holds civil law to a higher standard of justice or objective use. Zosius took this one step further in his discussion. He held that the moral authority of jus gentium was not limited to the rights and obligations of man, but also extended to the rights and obligations of communities. As a result of the progress of life, communities were transformed naturally into civil societies. Although civil societies were governed by specific civil laws, the rights and obligations that extended from jus gentium transcended these civil laws, and indeed could hold them accountable, again, to the higher criterion of justice. This was the case because all bodies of law, no matter what community created them, contain aspects of jus gentium, which he argues are the customs held in common by all mankind across time and space. Further, for Zosius, it's not only the case that all men were created equal in relation to jus gentium, but so too all communities were equal in relation to jus gentium. As all communities were equal before jus gentium and encompassed not only the customs practiced between communities in times of war, but also those practiced in times of peace. In this respect, jus gentium was at the basis of the exercise of legitimate force between societies, insofar as it enabled one community to vindicate its rights and protect its boundaries against another, and it was at the basis of the exercise of just force by individuals within society, insofar as it enabled man to protect himself, his family, and his property against threats by another. This makes sense for Zosius if you remember that he's writing from an imperial city in Freiburg within the Holy Roman Emperor, where they're actually in a process of standardizing rights and laws and trying to figure out how the communities are supposed to live and relate to one another under the empire. Alciati writes from a different perspective. He writes not only from the perspective of Milan, from being in Milan with the outset of the Italian Wars, but also being called to France on several occasions to teach on behalf of Francis I. So he's both arguing against the incursions into Italy by the French, but also arguing in a way that doesn't quite get Francis I too upset, because he does attend his lectures and listen to what he has to say about these things. Although natural law and jus gentium were not coextensive for Alciati or expressions of the same thing like they were for Zosius, they were not entirely separate from one another. They were historically and morally conjoined via use. Subjective use as a fundamental right of man stood at the basis of the moral authority of jus gentium, whereas objective use as the art and equity of good conjoined stood at the basis of the moral authority of natural law. In Alciati's case, natural law and jus gentium are not two expressions of the same thing, but rather two different sides of the same coin, if you will. Natural law concerns justice, whereas jus gentium concerns force. Within civil society, natural law, on account of use, that is good and equity conjoined, holds civil law, the least inclusive category of law and potentially the least just, to a higher standard of justice, according to Alciati. If and when civil law violates natural justice, that is objective use, it must be reformed. Moreover, if a civil law is unjust, if it violates objective use, then one is morally justified in not yielding to the law. This is the case, Alciati argues, because in nature all men were created equal in force, whereas in civil society all men are equal before the law. As such, they must restrain their use to meet force with force and agree to settle their disputes in courts, which in turn promotes the security of society as a whole and provides moral legitimacy to those who administer and approve the laws within it. It turns out that Thomas Hobbes sounds a lot like Andrea Alciati, instead of the other way around. If civil law is unjust, if it has the capacity to place one under the arbitrary power of another, then the condition of man lives in is not a condition of peace, but rather a condition of uncertainty, insecurity, and tyranny. It turns out that John Locke also sounds a lot like Andrea Alciati. If civil law becomes arbitrary, if those who administer the laws attempt to diminish or demolish human liberty by splitting good from equity, then the entire artifice of civil society has the potential to come into question. Although man agreed to restrain his right to meet force with force in civil society by placing his neck under the laws, it is significant that he did not alienate his use altogether. Precisely because man restrained his right to use force in exchange for justice, if and when civil laws violate objective use, justice, man still has recourse to subjective use, force. Am I running out? Am I fine? Okay. In passively resisting an unjust law, one is essentially calling for reform to bring the laws back into accordance with justice. However, not surprisingly, only properly trained jurists and lawyers, those who understand use in both its objective and subjective aspects, can reform unjust laws. This is something that they both argue still has to be in the hands of the people who know, the jurist. In Alciati's discussion of jus gentium, man's subjective use prior to civil society mirrors the rights of legitimate rulers, inferior and superior princes outside of civil society, and thus beyond the reach of mere civil laws. Beyond civil society, on the level of dukes, princes, kings, and emperors, it is force, not justice, that is the main criterion of analysis for Alciati. On the level of rulers, because there is no shared law to which they are all subject, only customs in common with jus gentium, there can be no justice between them. Nonetheless, the lack of justice does not signify inequality, as all legitimate rulers have a right of war in accordance with jus gentium, and thus stand in relation to one another as equals. Moreover, for Alciati, all wars are just, because all enemies are just. In other words, because all legitimate rulers stand as equal in relation to jus gentium, they are all just enemies in relation to one another. Those who are not equals are bands of brigands, robbers, and pirates, not enemies, properly speaking. Furthermore, because all persons regarding a time and place are also equal into relation to use, the fundamental definition meaning the right to meet force with force, also puts individuals at the same level for Alciati. So for Zazius and Alciati, the most fundamental, universal rights that people have doesn't come from natural law, it comes from jus gentium. And it comes from jus gentium because we live in a world of practice and not just in moral precepts. They argue that without jus gentium in use, there could be no liberty, no security, no sovereignty, no subjects, and no citizens. Without just laws and just force, there can only be arbitrary force and insecurity among and between men, banded brigands, pirates, and robbers. Natural law is important, but it's not as important as jus gentium. So I wanted to suggest in conclusion that one of the reasons why we study the history of human rights, and we don't often see discussions of jus gentium, and certainly not humanist jurisprudence in that history, is twofold, I think. And I'm just at the point now where I can start to put it in some words, but they're not yet fine, polished, and unfuzzy, clear words. So please bear with me. I think that two sleights of hand are affected in the 17th century. And I think these two sleights of hand have a spell over people who study the history of rights since the 17th century. And I think one of them, both of them are used to justify the rights and powers of states over those who were subject to their jurisdiction by choice, as well as those who were conquered by force. I think the first was the transliteration of universal rights that transcended states and that were shared among all humankind, regardless of time and space, into natural rights associated with a specific place, time, and people, namely the state of nature from which those who founded a specific body politic originated. That limits the scope of who gets rights because the people who found the state, based on the theory of the state of nature, then get to determine the inequalities within and justify them in any manner of ways, including a transliteration of jus gentium, I think, which is the second. So the second transliteration of jus gentium as customs in common shared among all people, including commerce and trade, and to wage war and conclude peace, gets transliterated not from the rights of all people, but into the exclusive rights of European empires and nation states. And it's a really interesting sleight of hand because on this most basic level, in the 17th century and certainly by the 19th century, the process of changing the meaning of jus gentium turns a relatively benign category that enabled individuals who lacked citizenship to use Roman law to protect their interests within the Roman dominion, as well as for communities to enter into treaties with Rome. It changes it into fundamental principles that can be used by Europeans to vindicate all manner of violence unleashed by conquest and colonization, including slavery and the other things. These transliterations didn't occur independently or in isolation. They're not cause and consequence, but they're justification or a way to justify emerging nation states and a new way of these empires to relate one another, especially their theories that go north, and so they kind of ignore some of the stuff that's happening in the southern world, I guess. Italy, they ignore a lot of things in the north that happen down here because England is now trying to justify everything. I think what's interesting about this is that these arguments are not unknown. These arguments are not, they're new when you hear them, but then people who've been studying this stuff for a long time will say, oh yeah, I remember that Zazius said that, or oh yeah, I remember that Altradius said that, or Guillaume Bidet, who is, I'm not speaking about here, but is on the sheet. But I think that if we actually looked at these, you might realize that there are some very strong and very important critiques of this linear story about the development of natural rights from natural law already in the 16th century. And that it might be useful, instead of trying to kind of think about this as recovering something that was lost, maybe to look more closely at something that is perhaps deliberately unseen because it doesn't do the work that it needs to do for the 17th century theorists, and especially for the 19th century theorists when they get to the scramble for Africa. And that's my thing.